The Federal Trade Commission just proposed a rule that, as currently written, would ban non-compete agreements for employees and independent contractors nationwide. This would be a monumental shift for this area of law. That being said, employers who use non-compete agreements shouldn't worry yet. First, it's only a proposed rule. The rule is open to public comment for 60 days and subject to further revisions before the final rule is published. Once the final rule is published, businesses would have 180 days to comply. Second, and perhaps more importantly, it's questionable whether the FTC has the legal authority to issue this type of rule. We predict the rule will be subject to legal challenges and injunction efforts. Still, everyone should be aware of the scope of what's being proposed. Here's a brief summary.
The FTC's rule as currently proposed would prohibit employers from entering into new non-competes with current and former employees, independent contractors, and other workers. It would also retroactively abolish existing non-compete agreements. Employers would have to contact individuals who are subject to a non-compete and tell them that it's no longer in effect and can't be enforced. In its current form, the rule would also ban de facto non-compete agreements. The FTC defines this term broadly to include any contractual provision that has the effect of prohibiting a person from seeking or accepting employment or operating a business after the end of the person's current job. So while confidentiality and non-solicit covenants would still be allowed as a general matter, if they are drafted in a way that is overbroad, the rule may also void these and other non-disclosure agreement terms. The current version of this rule has very limited exceptions. For example, non-compete agreements would still be allowed in the sale of business context, but only for individuals who owned at least 25% of the business.
For now, companies should stay focused on making sure their non-compete agreements are enforceable under applicable state law. This is particularly important for companies with workers in any of the many states that have recently passed non-compete reform laws, such as Colorado, Illinois, Massachusetts, Oregon, Virginia, Washington, and many others. Feel free to contact our team if you have questions about the FTC's proposed rule, submitting comments to the FTC, or any other issues relating to non-compete agreements. A full analysis of the proposed rule is on aikengump.com.